Court is now in session. Be seated, please.
Let's have argument.
It's my demure, Judge, but I think the state has actually got the burden here, so I think I need to. Judge, let me hand you up a copy of State versus Meeks, 309 Georgia Appeals, 855, 2011 case. That's the case I'm going to ask you to take a look at.
And for purposes of argument, are we going to take it as the state waiving opening?
Yes, Judge. Sorry.
Okay. All right, so we'll have two arguments. We'll have yours and then you'll have last set.
Thank you.
I'm fine with that. I just felt like clarity was a good idea.
Judge, we have filed this special demurrer to count 6. Specifically, you can look at paragraph 7 of that motion. We set out what the law there is, and this comes straight out of State versus Meeks. Generally, an indictment which fails to allege a specific date on which the crime was committed is not perfect in form and subject to a timely filed demurrer. Our courts have recognized an exception, though, where the evidence does not permit the state to identify a single date on which the offense occurred. The exception does not apply unless the state presents evidence that it cannot more specifically identify the date of the charged offense. This is obviously very common in child molestation cases, Judge, where you've got the only evidence that you may have of an offense date is that of the memory of a child, and sometimes it can't be narrowed down to more than a month or a year. I ask the court to specifically look at the indictment count 6. This is the way that it's charged. The accused did request that CD, the minor female under the age of 18, provide the accused with a photograph. That is how it is charged. The date range that is given is between March 1 and June the 18th. The testimony that you heard is that, if I understand Mr. Boring's examination and statements of the detective, there are in fact 0 dates, no dates, where that specifically occurred, where the defendant did request that the minor female provide the accused with a photograph. However, there were 3 dates that were identified that, according to the detective, suggested that. And those were March the 7th, May the 5th, and June the 18th. So what you have heard, the evidence that you have heard, is that the dates that go specifically toward the language of the indictment can be very specifically narrowed down to 3 dates. They've not indicted it that way. They've indicted a range over a couple of months. And now, the state comes in to suggest very slickly that the indictment says something that it doesn't, and that is, well, what we're really talking about is a series of grooming over a couple of months. You have to look at these dates in context. If that was the state's theory, they could have indicted it that way. They could have specifically indicted that the criminal attempt was some series of grooming acts over this period of time. That is absolutely not how it is indicted. by looking at the indictment, which is very specific, did request that she provide the accused with a photograph. The best the detective could come up with was 3 days. Okay? So if they can narrow it down to 3 days, this indictment is subject to demurrer. And this is exactly what State versus Meeks talks about. For the record, that's 309 Georgia Appeals 855. This is a 2011 decision. Again, they start with the general rule. Generally, an indictment or accusation which fails to allege a specific date on which the crime was committed is not perfect in form and is subject to a timely special demurrer. They talk about the exception. Although this court has recognized an exception to this rule where the evidence does not permit the state to identify a single date on which the offense occurred, the exception does not apply unless the state first presents evidence to the trial court showing that it cannot more specifically identify the dates of the offenses. Try as they might, Judge, by suggesting, allowing the officer to testify, well, you got to look at it in context. You got to look at it in context. That's not the way it's indicted. The testimony before this court is 3 specific dates. Okay? And the reason why it can be narrowed down to 3 specific dates is because the evidence that the state suggests they have is all electronic. It's all data which is captured and available not just to the date, but to the very minute and second. They absolutely can make it far, far, far more specific than they have. If an indictment or accusation alleges that a crime occurred between 2 particular dates, and if evidence presented to the trial court shows that the date can reasonably narrow the range of dates during which the crime is alleged to have occurred, the indictment or accusation is subject to a special demurrer. In this particular case, State versus Meeks, and obviously this is, in that case, Judge, the trial court granted the demurrer, and the trial court upheld the demurrer. The indictment in that case said, as to counts 1 and 2, I believe those charges were electronically furnishing obscene material to a minor. That indictment said that between June 1, 2007 and August 16, 2007, electronically furnish obscene material to a minor and contribute to her delinquency. The court considered the testimony that was given by the officer and reasons ordinarily the date on which a document is created or saved on a computer can be established. Well, we heard from the detective 3 very specific dates, as well as the date on which the email was sent or received. The state gave no explanation as to why the investigating officer was unable to simply ascertain those dates from his examination of the victim's computer. The officer was unable to recall why he failed to do so. Again, Judge, we don't even need to go that far, because the officer is giving you 3 very specific dates. There's really nothing more to consider. In this case, the court agreed with the trial court that the state had failed to demonstrate an inability, burdens on the state, an inability to narrow the range of dates within a 2.5 months as alleged in the accusation. The court then affirmed the demurrer as to counts 1 and 2. That's exactly what we've got here. They give a very large range of dates with a very specifically worded indictment. The evidence you have is, yet, as to the way it's indicted, did request that she provide the accused with a photograph. The officer himself identified 3 dates. This is absolutely subject to a special demurrer. Judge, we're going to ask you to quash this indictment.
The entire indictment?
Yes, ma'am.
Judge, I'll start with that. The law is at this time that if Your Honor even found that you're going to quash a count of the indictment, it does not quash the entire indictment. it would only be that one count. I believe there's a recent case either from this spring or back in 2014 that specifically addressed that. Your Honor, one thing I want to start off with, I think that is one of the most important points here, is that this is a criminal attempt case. A criminal attempt to commit a crime in which the state has to prove the defendant's intent to actually follow through with this crime and substantial steps toward the commission of the crime. And it is a jury question or a trial, the fact question down the road as to when that actually happens. I know the defense counsel stated that we're coming in here making a slick argument, but this is exactly why this case was indicted the way it was. If it had been indicted any differently, if it had been indicted, okay, we're going to take this statement and put it in an account, we're going to take the next statement and put it in an account, the defense would then be arguing, okay, well, this one in and of itself, that's not a substantial step. This other one in and of itself, we don't have proof to prove a substantial step. The third one, we don't have. As they've already argued at a probable cause hearing in this case, they've made arguments that this was some type of fantasy communication, that he never intended to follow through on these type of acts. This indictment was drawn up specifically to combat those types of defenses. To start with the Meeks case, Judge, the first thing to point out is, on that case, that was a completed offense. Of course, when that actual act is completed, it is there, and they had a date they could have put in for when it was completed, when the intent was completed, when the substantial step was completed, because you had a complete crime. In the Meeks case, the officer stated that he had no idea why he couldn't give exact dates. You have testimony from Detective Stoddard and argument from the state now as to why we did not put a specific date in the indictment. As far as reasonably narrowing the dates, there was a fourth, February 28, 2014, a fourth message that evinced an intent to get a photograph of C.D.'s vagina. That actually we have narrowed even further in this indictment. We could have gone even further back to February 28 and arguably to December 2013 based on the one-sided conversations of the defendant that we have. So we've actually narrowed it more than we have to. In the Meeks case, they did hold that the officer, it was insufficient for them to say that there was no idea why he couldn't give dates. They did hold that all the state has to do is give an explanation as to why they can't narrow the dates in the indictment. In this case, with an attempt case, we have to prove his intent. And this is a case in these acts that you have to consider the totality of it. You have to consider all of the steps that he took every time he requested or referenced seeing her vagina in context with all his other graphic conversations with her, and proving that it actually rose to criminal intent and it rose to a substantial step. Your Honor, as far as the cases I've presented to you, I would point you, first of all, to Colbert versus the state. That case simply is cited as 255 Georgia Appeals 182. It's just a criminal attempt child molestation case, and it discusses intent and substantial step in a criminal attempt case. So it just illustrates that there is an intent and a substantial step necessary, and you have to prove those things. And it's up to the jury to determine when and if that actually occurred. Importantly, I'll turn, Your Honor, to Clark versus the state, which is 317 Georgia Appeals 471. That's actually another type of case in which date ranges are applicable because it is something of an evolving intent. In Clark versus the state, the defendant was charged with 9 counts of theft. There were different date ranges for different offenses about when these thefts were to have occurred. This was an ineffective claim based on a failure to file a special demurrer. In that case, the special demurrer, the argument was that a special demurrer should have been filed because the date ranges alleged were faulty, and it should have said, the indictment should have said, unknown to the grand jurors. What is important in that case is that the court reasoned in denying the ineffective claim that it was unclear when the defendant exactly developed the requisite intent as to each charge, and that it was appropriate to have those date ranges when it was impossible or unclear as to when the actual intent evolved. And in this case, it's going to be a jury question if and when it got to the point where this is a criminal attempt to commit a crime. Your Honor, Keener versus the state, which is 215 Georgia Appeals 117, that's a 1994 case. It's a criminal attempt armed robbery, and it talks about, in these cases, defendants will often argue mere preparation. I assume that the defense down the road will argue that in this case, that there was no intent and there was no substantial step. That is the reason why we have indicted this case the way we have based on these facts. Your Honor, I believe that the reason the defense is arguing this is because it appears that they're arguing that they should be allowed to have a separate account of each count and then be able to argue that one is not enough. And that is why we have provided and indicted the case this way. Your Honor, finally, I would add that in this case, looking at it, first of all, I believe based on what we can and what the detective has testified to, we have narrowed it as far as we can, and probably more so than we even needed to prove the criminal attempt to complete this crime. Just the standard, if Your Honor is to deny this motion or deny this demurrer, then the review, if it goes up on interlocutory appeal, would be to address whether that is the case and whether it is perfect in form. However, Your Honor, that is not required. The review based upon post-trial, if there were a conviction in this case and it was reviewed post-trial, is basically just harmless error, and if the defendant was on notice and could have a defense to these charges. Your Honor, I don't believe there's any allegation, just for the record, that anything's been argued relevant to that to show that somehow the defendant is prejudiced and is not able to meet or defend these charges based on the way the indictment is drawn. And in fact, I think if you look at it practically, if he had been drawn, it had been drawn with separate counts, he could actually be looking at more time. So that would be, it seems like there would be more prejudice from that.
All right. Well, I certainly can deny any motion to quash the entire bill of indictment. As to the defendant's motion number 8, which is the special demurrer to count 6, I'm going to deny that motion. And I need an order from the state.
Yes, Your Honor.
All right. Next matter.
The next motion for today, Judge, is the motion to sever unrelated and properly joined offenses.
Oh,
I think we're ready on that. I don't really need to make an opening statement.
oh.
I don't need to make any opening statement, Judge.
Is there evidence to that?
We're going to put the detective back up just briefly.
Come back, please.
This one.
Even though he's already been sworn, I think it's more prudent to swear him again.
You solemnly swear affirming testimony shall give to the court on which you know can be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, Detective, the subject of the last motion we were talking about was the individual known as CD.
Yes, sir.
And
I'm sorry, I need to interrupt. Exactly what counsel were using the
I guess I should make an opening statement.
That's okay. Give us some of that.
It's motion 3.
Right, I've got it. I just want to know which count.
Right. That would be, we're asking to sever counts 6, 7, and 8.
Thank you.
All right, and you interviewed this young lady on 2 occasions.
That is correct.
the first time you spoke with her, it was just on the telephone, right?
Yes, sir.
Okay. And she told you at that time that she knew that Ross Harris loved Cooper a lot,
Yes, sir.
that they had taken him to the beach a couple of weeks ago, and that Ross Harris had sent her some of their beach pictures, which included Cooper.
That is correct.
She told you emphatically, promised you that he would never do anything to hurt that baby.
That is correct.
She told you that Ross Harris told her that he loved his wife and would never leave her.
That is correct.
And she told you on June the 22nd that Ross always talks about Cooper, wants Cooper to go to Alabama, and how smart Cooper was.
That is correct.
You didn't clarify with her where these conversations occurred, whether they were on the telephone or on some social media app.
No, I did not.
All right, so you talked to her again on June 30th, and she advised you that she began conversing with Ross Harris on a social media app. I think she told you it was Whisper.
That is correct.
Okay, and she told you that she had actually posted something herself on Whisper, which he apparently responded to.
Yes, sir.
Okay. She told you that she had read the book 50 Shades of Grey and that she posted something about it.
Yes, sir.
All right, and then she sort of described kind of what happened from there. Essentially, they communicated, became friendly, and started communicating on another app called Kick.
Yes, sir.
And that's the one that we talked about when you testified a few minutes ago.
That is correct.
All right. In talking to her, you learned that she was a student. She was taking classes at Lanier Tech.
Yes.
Okay. And she advised you that Mr. Harris had counseled her to stay in school when she was contemplating dropping out of school.
Yes, sir.
Okay. She told you that at one point in time she had feelings for him, but Ross Harris told her it would never happen because he was married.
Yes, sir.
And then, of course, she explained to you that they had, in fact, exchanged photos online.
Correct.
Okay. And you asked her, what made you do that? And her response was, because I really liked him.
That sounds, I'm sorry, that sounds correct.
Okay. And you asked her, did he ask? And her response was that he had not pressured her.
That sounds correct.
Okay. And she indicated to you they really did not talk that much.
I don't think that's accurate. I don't remember that exact statement, sir, but we can go ahead and say that they did talk.
Okay. You got a transcript, man?
I do not have a transcript of that conversation.
And you asked her specifically when he mentioned his wife, she said that you asked about his wife, and she said when he mentioned his wife, he wouldn't say anything bad about her.
Correct.
And then you specifically asked her, would he say he wanted to end his relationship or was looking for a different relationship? What would he say? And would it be fair to characterize that her response was rather adamant? No, never. He said he would never leave her.
Correct.
And you asked again about Cooper. When he talked about his son, what would he say? And she essentially repeated some of the same that she had told you previously a couple of weeks earlier. Talked about him going to Alabama. He would say, my boy is smart, he's handsome.
Yes, sir.
In a nutshell, that's basically what the conversation was.
Yes, sir.
Okay. And from your direct, it's certainly fair to say your investigation, you believe that they were messaging or through some social media app for a period of at least 6 months?
Yeah, at least.
Okay. And there were photos exchanged?
There were.
Okay. And some of those photos were vacation trips, and she sending pictures of her prom, things like that?
That is correct.
That you discovered, in fact, that in all this time, they never actually met in person?
That is correct.
Okay. You previously indicated that there was some discussion or suggestion about meeting up or hooking up that occurred on occasions during this time frame we're talking about, right?
Yes, sir.
Okay. But you would agree there certainly was no discussion about running off together?
None.
No discussion about, there was certainly no suggestion that they were going to be a couple.
None.
Okay. Never discussed having a life together, right?
No, sir.
Right. You've already indicated, I believe, that he certainly never conveyed to her that an intent to leave his wife.
Correct.
And as far as his son goes, as far as Cooper goes, you didn't discover there was any communication between them where he spoke negatively about Cooper in any way.
No, sir.
In fact, it was quite the opposite. Is that fair to say?
Yes, sir.
Any comments about his son, few as they may be, they were positive in nature?
Yes.
Since then, Detective?
I have not.
Okay, so essentially the two recordings that I have would be all the interviews y'all done of her.
Yes, sir. All of that I've done.
Has another police officer interviewed her?
Not that I know of, sir.
You're certainly not aware then of any other communication between the two of them, and I'm talking about CD and Ross Harris, no other communication involving Cooper Harris?
No, sir.
All right, I think that's all I need to get right now, Judge.
Okay. Defense counsel asked you some questions about the defendant, I believe, sending photos from the beach.
Yes,
Was this a few weeks before the child's death?
that is correct.
Okay. And these photos he sent from the beach, did he also send other messages and things like that during the midst of this trip he was on to CD?
That is correct.
Were those also sexually graphic in nature, things of that nature?
Yes, sir.
I know you stated, or you were asked if he ever said anything to her about leaving his wife for her or anything like that. In talking with Chelsea, didn't she in fact confirm that the defendant had admitted he had cheated on his wife before?
Yes.
And in fact, in this case, didn't she also talk about, or say the defendant said he'd had problems in his marriage with Leanna Harris, but he would not leave her?
Correct.
Through your conversations with were there other people that you interviewed in this case?
Yes.
And were there other witnesses and other women that the defendant was involved with, both online and personally, who said things to the contrary?
Correct.
So in addition to the defendant admitting to infidelity to CD, did he also attempt to meet up with her to engage in sexual relations outside of his marriage?
Correct.
And the last time, I believe, was that while his wife was out of town just a few weeks before the homicide?
That is correct.
Now, in addition to that, in this relationship, ongoing and things of that nature, going to June the 18th, 2014, day that Cooper died, did he have communication during the day while Cooper was out in the car dying with CD?
That is correct.
And was it just more than one communication? Were there texts back and forth throughout the day?
There were.
And were these also, as I think we've discussed earlier, sexual in nature, pictures sent back and forth?
And they were.
And from your investigation, was this something consistent he was doing, messaging and engaging in these online and in-person affairs outside of his marriage?
That is correct.
And in your investigation, did you uncover evidence that showed or evinced the defendant's desire to have these relationships and to engage in these relationships and to not be a part of this family anymore?
That's
I'm going to object, let it go a little bit, but I think we're getting kind of far afield. What we're talking about is count 6, 7, and 8. Specific charges involving a specific individual during these time ranges we're talking about. What the state wants to do is expand this way outside of what it is that we're actually talking about, Judge. Maybe an issue that dealt with a trial, but for purposes of severance, what we're talking about is specifically 6, 7, and 8. All these other matters that they want to discuss, they don't have anything to do with that.
Your argument.
Judge, in order to prove or show that these cases should not be severed, we're trying to show that the relationship was with CD, the affairs outside of marriage, hers were included, and on the day of the death, we have to show that there was some nexus. Why was he doing this, and how is it relevant to the murder charge? And so, them having raised this, I have to show, okay, this was evidence of motive. This is intrinsic evidence, and so I'm trying to show that, in fact, he did have a motive to engage in these and wanted to be free of this family relationship. And so I believe that ties into why the evidence of CD, which the only reason it's in the indictment is it's the one we have where it's illegal, why it should not be severed, and why would it be admissible at trial anyway.
You can proceed.
Okay. Did you, in fact, discover evidence, and Judge, I'll reserve a proffer most of this anyway, just to save time. But did you find evidence, just for instance, that he said, the defendant said, if not for Cooper, he would leave Leanne?
That is correct.
Okay, did he say that to different people on different occasions?
That is correct.
On the day of the death of Cooper, the day that he was also engaging in communication with CD and other women, did you uncover evidence specifically from that morning that evinced his desire to escape from the family situation?
That is correct.
Your Honor, I'm going to show the defense counsel, I'm going to show you the defense. Excuse me, the detective.
I know about this, but this isn't relevant to, doesn't have anything to do with count 6, 7, 8, Judge. Nothing.
Judge, again, this is going to be admissible to show that he did want to escape this because of his affairs and wanted to carry on a relationship outside of his marriage and family.
That doesn't make it relevant. Doesn't have anything to do with 6, 7, 8. We're getting so far afield from what this motion is, Judge.
Well, I don't find it far afield. I think 6, 7, 8 are part of the were indicted because this is the only person that was underage, as I understand what you all have been arguing. So to sever it, would pull that piece out of the state's proffer that they're going to show this evidence as part of intent and design. And they can go into this at this time because it relates directly as to whether I would or would not sever those counts.
Your Honor, may I approach the witness?
Yes.
Detective, showing you marked for identification purposes the State's Exhibit 1. Do you recognize that?
I do.
And how do you recognize that?
It is a whisper that was found during the examination of Ross's phone.
And is that an exact copy of the quote whisper we'll talk about in a second, and the conversation had after that on the morning of June 18, 2014?
It is.
Your Honor, I would tender State's Exhibit 1 at this time.
That's fine. I'm going to admit it over objection. We've had the argument, so that can be referenced at this point.
Detective, just going to show that regarding the motive of living or escaping from his son and escaping from this relationship to engage in all of his actions. What is Whisper, first of all? I don't know if we even talked about Whisper before to the judge.
Whisper is a social media site. People were able to put, they call them Whisper, they're text or posts that they can post supposedly anonymously. And they can just say whatever you want to say. Anybody out there having a bad day, anybody want to have sex, and does the whole range. And what they'll do is they'll put a whisper out there, and it's usually locally. They go by the phone GPS, and they try and keep it within a localized area. So when you're whispering and talking to people, normally it's within a certain location. These people are pretty close to you.
Did the defendant utilize this Whisper application?
Yes, he did.
Okay. How often?
There are over 5,000 whisper conversations and 40,000 actual texts on his phone.
And is that between starting in December 2013 to June 18, 2014?
Yeah, I believe it's December, maybe even a little bit before then, but around December.
Okay. On the morning of June 18th, at around 8:55 a.m., showing through your forensic tools, was a whisper sent out?
The whisper is...
And was it by an unknown person?
It was. A whisper was sent out that morning. It was responded to at 8:55 by Ross Harris.
Now, the whisper that was sent out that morning, can you tell what time it was actually sent out?
I don't have that in front of me. We did receive something from Whisper. I don't have that, but it was that morning it was created and sent out.
And to put this in context, what did this whisper say? First of all, let's be clear. Did the defendant actually write that whisper or send it out?
No.
Okay. Can you tell the judge what the whisper actually says?
The whisper that was commented on is, I hate being married with kids. The novelty is worn off and I have nothing to show for it.
Now, initially when you were looking at the forensics, were you able to prove that the defendant had actually viewed that or anything of that nature?
No, we were not.
Since that time, have you been able to tell that he did view that?
We have.
Okay. And on Whisper, when you view one of these whispers, do you have the ability to communicate with that person?
That's correct.
Okay. And when you do that, is that like a public post or is it a private message sent to the person who has sent this whisper?
It could be a private message sent to them.
And in this case, did you find evidence that the defendant in fact responded?
I did.
Okay. And could you tell the judge what was his initial reaction? What was his response to this whisper about about hating being married with kids and the novelty having worn off? How did he respond?
At 8:55 that morning on the 18th of June, he responds, I miss having time to myself and going out with friends.
Okay. Did the person who creates the whisper, do they have the opportunity then to respond and engage in a conversation?
That is correct.
And did she in fact, or assuming this is a she, did this person respond?
She did.
Okay. And how did she respond?
She responds back, and her screen name will be always in my feelings. Yeah, I have nothing. Every ounce of me is in perfect, unappreciated wife with 2 little ones that drain out the rest of me. I D&T don't resent my kids, I resent him.
Now after that, Did the defendant respond further?
He did.
Okay. How did the defendant respond relative to motive in this case?
He responds at 9:15 that morning. My wife gets upset when I want to go out with friends.
And did he make then another statement that specifically goes to motive?
He does. I love my son and all, but we both need escapes. And that was done at 9:15:33.
So he said, I love my son and all, but we both need escapes.
That is correct.
And what was going on at 9:15 a.m. per your records?
Per our records and per video, he is sitting at Chick-fil-A having breakfast with Cooper while having this conversation.
Is that about 10 minutes before he leaves Cooper in that car?
That is correct.
Does that other person then respond?
She does. At 9:18, she responds that maybe that's our issue too. I need a break from love.
And when she says, I need a break from love, does the defendant then respond?
He does. At 9:24, at 15 seconds, he says agreed. Then he says hug. And then at 9:24, 28 seconds, he says we both need that.
And additionally, go over most of this from Crawford. This is something we've talked about at probable cause hearing as well. One of the girls he spoke with talked about the fact that if not for Cooper, he would leave Leanna.
That is correct.
Judge, I will reserve the rest of that just to argue in Crawford.
I apologize. That was. Mr. Warren, could I get that again from you, sir? I'm sorry. You're reserving what article proper?
Oh, I'll just proffer the rest of the evidence and motive.
Okay, as to this post that somebody posted, do you have that with you?
I do.
No.
Oh, the judge has it.
I can see that, Judge.
Sure. I've read it.
All right. Up until very, very recently, you believe that Ross Harris had actually posted this statement, I hate being married with kids, the novelty is worn off and I have nothing to show for it.
And that's not correct.
It's not correct.
Not correct.
You did not believe that he posted that.
Mm-mm.
Okay. You never thought,
Well, when we
He's the
first
one that
saw it, Mr. Kilgore, yes, there was I did suspect that he had written it and posted it, but we did send out a court order to Whisper, and after receiving it back, now of course it's anonymous, you don't get the person's name, but when we received it back and due to the number of posts she had made and location that it was showing from, it's believed that someone else posted that.
All right. And you learned that fairly recently.
No,
All right. Bottom line is, you were wrong.
I was not.
You were wrong. You thought that he typed this out, and that's what you were proceeding under. You were wrong.
At the very beginning, there was a chance that he typed it. We didn't know.
All right, and so what you discovered was, in fact, Mr. Harris responds to lots of posts.
Lots.
Lots. It's fair to say that he responds to dozens and dozens of posts virtually every day.
Yes, sir.
Okay. And this is a post that happened to show up on his stream. It works sort of like Facebook, right? I mean, you turn your phone on, and if you go to that app, something pops up.
Correct.
All right. So this is a post that happened to hit his screen that morning of the 18th, right?
That is correct.
Okay. And And your testimony is that his response was, I miss having time to myself and going out with friends, right?
Correct.
And if I understand the argument correctly, is you're suggesting that he misses going out with his friends, that is motive for murder?
I think it's one little piece.
One little bit.
One little piece.
Okay. Couldn't just be that maybe he just misses hanging out with his friends.
Of course, but it could also be motive. Motive's a guess, and this is what,
Motive's a guess?
motive can be a guess. We're guessing. This is what we think.
Sure. And at the time we had the probable cause hearing, you suggested that the motive had to do with finances, that he didn't, he was upside down, or that he wanted to get money from a life insurance policy. So are you abandoning that now? That is no longer what you're suggesting motive is?
No, I'm suggesting that there's several pieces to motive.
Okay. So is the motive financial, or is the motive that he missed his friends?
I think the motive's all of it.
It's all of it.
All of it.
Probable cause hearing, you also suggested that motive had to do with a conspiracy with his wife, Leanna Harris. That somehow she was involved in Cooper's death.
I never said anything. I don't believe I brought Leanna up hardly at all during the hearing.
Your testimony is then that you did not suggest that.
You're saying suggest. What I'm saying is we have not found any evidence to suggest that there was conspiracy. I'll leave it like that.
All right. Well, how about leave it like this? There's no evidence at all that Leanna Harris is involved in anything, is there?
It's circumstantial. That's it.
Circumstantial?
Circumstantial.
Okay. Well, I mean, this is important. The judge has got to decide. You're saying that it's motive because he wanted to be with his friends. And
Yes, sir.
Okay. But at the same time saying, well, maybe she was involved.
And why could not?
You tell me. It's your case.
Well, if you want me to guess, or you want me to throw out theories, would it be more likely that he would talk to his wife and get her thinking a certain way before he did the crime?
You got no evidence of anything like that, do you?
Once again, circumstantial. Stuff that she says, that he says, match up.
All right, so you're holding on then to at least three motives. Financial, he doesn't get to see his friends, and he's in a conspiracy with his wife.
Objection, that's misstating what he said. He never said that he was in a conspiracy with his wife. Not what the detective testified to.
He has no cross.
I think technically it's direct,
I
but
think so too.
yeah.
Yeah, I think it's not right. That's.
It is direct, but I can ask leading questions because he's an officer.
Oh, well, I don't know about that. I'm not sustaining objection.
If I could.
That's not the only reason I'm sustaining the objection. I would suggest you be more artful in your questioning, which I believe you're
That's fair.
perfectly capable of.
That's fair.
doing.
Thank you, Judge. All right, so
And it's argumentative,
that's my job.
which means you can argue.
All right. So it's fair to say then that you're still suggesting there's three possible motives. Is there another one?
Oh, there could be.
Could be.
Oh,
So
definitely.
you're still looking.
Well, there's some motive if you're asking. And once again, there's the motive of the sexual relations. The motive actually being able to do this without having to worry about, having Cooper and that responsibility.
Sure. Well, Detective, did your investigation conclude that having Cooper and being married wasn't any impediment to anything that he was already doing?
Mm-mm. No, I think it was, because there are several occasions when he would like to do stuff, or stuff was said for him to do, and He did have, and I will not say Cooper was a burden, but he did have the responsibility of Cooper. He had the responsibility of Leanna, his wife. Lots of responsibilities.
This, this chat that occurred that morning, do you know how many other whispers, chats that he was involved with on the morning of the 18th, number-wise?
I can't give you a number right now.
Okay. But this wasn't the only one?
No.
All right.
But it was the only one while he was at Chick-fil-A.
Okay. And so you're saying while he was at Chick-fil-A, he, in response, he said, my wife gets upset when I want to go out with friends. And then he immediately responds, I love my son and all, but we both need escapes.
That is correct.
And so your testimony is that is evidencing motive of murder. Is that your testimony?
I think it's evidencing motive of murder, the whole conversation. The conversation is he's talking about I hate being married with kids, and Alvy is worn off. I have nothing to show for it. When he says agreed, hug, we both need that, he is pulling into Cumberland, 2600 Cumberland. So as he's pulling into Cumberland, has not dropped his son off. He's talking, he's actually texting, he's whispering. She's like, maybe that's our issue too. I need a break from love. And he's like, agreed, hug, we both need that. I think that leads to motive.
Well, I want you to be real careful, but I want us to be real careful with what your words are here. He did not type or say, I hate being married with kids.
That is correct.
He didn't type that.
From our investigation, no. Information I have now, no. He did not
So
type
you're
that.
holding out the hope that maybe he did type it?
I'm not holding out any hope.
All right. In fact,
I'm trying to put a factual and truthful testimony forward.
what your testimony is that you believe what he typed was, I miss having time to myself and going out with friends. My wife gets upset when I would go with friends. I love my son and all, but we both need escapes, right?
True.
And where he said that part about, I love my son and all, but we both need escapes, that's immediately, in fact, it's together when he's talking about going out with his friends.
It's 20 minutes later.
Well,
8:55, I miss having time to myself and going out with friends. That's right before they get to the Chick-fil-A. She responds, 9:12, they're at Chick-fil-A. And then he says, my wife gets upset when I want to go out with friends. I love my son and all, but we both need escapes. And that's while he's sitting at the Chick-fil-A with Cooper, enjoying their last breakfast together.
sure. When he talks about going out, his wife being upset with going out with friends, that's 9:15:15.
Yes, sir?
And 18 seconds later is when he talks about loving his son and we both need escapes.
That's true.
So isn't it fair to say what he's talking about here is, an escape is, he's talking about his friends. He needs more time to hang out with his friends?
He needs an escape. He's an escape from his son, is how I read it.
It doesn't say that though.
It does. I love my son and all, but we both need escapes.
He doesn't
That's what it
say he needs
says.
an escape from his son.
He does not sit there and say, I need an escape for my son. What he says is, I love my son and all, but we both need escapes.
And you certainly would agree that nothing in this particular chat, and we don't know who this individual is, right?
And we do not.
That nothing in this particular chat has anything at all to do with the individual we've been talking about, CD, in counts 6, 7, and 8.
Incorrect.
Nothing to do with it.
No.
Okay. You've not used the word child-free while we've been in here, but is that still your theory that he wants to live child-free?
Oh, I think it's one of the motives, yes.
Okay. Well, let's talk about that a little bit. You
Okay.
testified at probable cause hearing that you found that there had been that Ross Harris went to a subreddit that was called Child Free. And Child Free is people who advocate living child free. They advocate not having any more children and adding to the biomass, right?
That sounds correct.
Okay. And you had a chance to review his computers?
That is correct.
And this subreddit you're talking about, that was viewed on his work computer?
I believe it's Lenovo.
Lenovo work computer?
I believe so.
Okay. All right, and you would agree that you could tell that there was no Google search for anything called child free, right?
That is correct.
The way that, and I don't use Reddit, but the way essentially it works is it's kind of like a clearinghouse for posts where people can talk about different subjects, right?
I would say that's accurate.
Just generally, that's basically what it is. And what you found was in April, he clicked on 3 posts. Is that accurate?
That's accurate.
All right. And so what your testimony was at the probable cause hearing was that there were, that's what you were talking about, was these 3 posts that he clicked on.
Correct.
Not a search, but a click.
Correct.
All right. And the total time that he looked at these posts, and when I say posts, it's just basically a person typing in whatever's on their mind, right? Kind of like we do on Facebook.
That would be accurate.
Okay. But the way they do it in Reddit is they try to categorize it in different classifications and categories. Is that fair to say?
Yes.
Okay. And so the total time that in April of 2014 that these posts were clicked was what, 5 or 6 minutes, something like that?
I don't have the times in front of me, sir. I'm sorry.
Don't have it? Okay.
I don't have it.
And you didn't find any evidence that he was a member of any subgroup or subculture called child free, did you?
No, sir.
And in fact, there are several of these groups or subcultures that inhabit the internet posting their philosophies.
Yes, sir.
Living child free.
Yes, sir.
And you didn't find that he was part of any of those groups?
No, sir.
Nor that he followed any of them?
No.
They weren't saved on his favorites or anything like that?
No, there's no evidence of that.
And after these couple of minutes in April, you never found that there was any other sort of contact with that particular topic?
No, sir. No evidence was
All
located.
right. And you've read what the posts were, correct?
Oh, the Reddit site? Yes, sir.
All right. One of the posts was from a 23-year-old blind man who was ranting about how hard it is to get a date because he's blind. Is that fair to say?
That's fair to say.
All right. One of the posts was from a lady who had posted a photo of her IUD and suggested that she was pregnant, and then she was sharing the responses from her friends for that posting. Is that a fair characterization of what it was?
That's fair.
Okay. And then the third one was from a young lady who was speaking with a family member who was apparently had just gotten out of prison. And this family member was trying to talk her into having a baby and then giving it to the parolee. Is that a fair characterization?
Yes, sir.
All right. So when we heard about child free as relates to motive, is that what you were talking about?
That's the site I was talking about, yes.
That's it. Okay. None of that suggests that he adheres to some philosophy of murdering his child, does it?
No, sir.
But it sounded good in the probable cause hearing, didn't it?
It sounds good now. It's still a child-free site that he went to.
Sure.
He clicked on multiple times. Curious, maybe?
Maybe. Maybe. All right. I think I may be right with that, Judge. You can just 1 moment.
I will.
I think that's all I've got.
I don't have any further questions, Judge.
You may step down.
Thank you, Judge.
That's all right.
Thank you. You ready to ask this argument?
Yeah. I guess I should request that during making proper he wants to make, in case that's something that we need to address.
I agree.
Judge, and part of this was included in the brief sent to Your Honor and Defense Counsel filed this morning, just regarding most of the legalities of this and some of the facts in the statement of facts. Other evidence that we would proffer showing the marital relationship and conversations with these numerous other women and this nexus to motive to being unhappy in his marital relationship and family relationship. First of all, he did talk to one of these women who was 18 at the time when they met, J.M., I will refer to her. It's obvious through the messaging that he had deep feelings for her. He actually tells her in the spring of 2014 that he loves her, that he misses her. During the messaging back and forth with her, he gets upset that she keeps disappearing. She keeps disconnecting from this messaging. And then she will show back up and they'll start talking again. This is another person they in fact tried to meet up, and he did meet her one day. She lives in Middle Georgia, and she described that she was going to a store or something in town that day. He said, "I'm going to go meet you." She thought he was joking. Sure enough, he shows up in the parking lot. This is a person that he had a relationship with on for a while. Seemed a bit more deep than the other relationships he had online, even though they were numerous. This person, on June the 13th, he stated that he missed her. Says she tells him that she's back to her boyfriend. Then on the 17th of June, the day before the death of Cooper, defendant says, "You're gone again," because she doesn't respond, and he says, "That makes me sad." And on the day of the incident that morning, he says, "Good morning," and she never responds. During that context, he several times asks her, or she asks him once in March of 14, excuse me, that's a different role. Through the context of that relationship, Judge, that is something where it shows he is carrying on. He actually had met her, talks about love, and things of that nature. There's another girl in March, she asks him if he loves his wife. He says, "Yes, but I hate our relationship and I greatly dislike the sex." He talks, honestly, Judge, with a number of women about his unhappiness with his wife. To one of the women, C.H., June 4, 2014, he talks about being the guitarist in a church. While they're in the middle of this conversation, they've had sexual conversations back and forth. He brings up that he's a guitarist in the church. She responds, quote, "But you still exercise the thought of being with someone else when you're married?" The defendant responds, "Yep." She then asks him, "Does your conscience ever kick in?" He responds, "Nope." The person, CH, then asks, "What are you going to do about it?" And at that point he says, "I don't know." This is 2 weeks before Cooper's death. He says numerous times, and you'll see this in the argument, when we make argument, he refers to himself as a sex addict, or that he is addicted to sex and cannot get enough of this and enough women. He says at one point that one post, he misses being single, just wants to go out and do things, not that language, with a lot of girls, get drunk and have fun. Back to the girl J.M., he led her to believe that he was not messaging other people. She told the police initially that the defendant had told her his marriage was falling apart, that they were fighting, he and his wife, about money and other things, that his wife had caught him cheating. And this is a girl that, per the messaging, the defendant lets this girl know that his wife had discovered their texting and messaging back and forth. In addition to those specific comments, judges, the evidence we would expect to show would be just pervasive as far as his online relationships, both messaging, specifically in the spring weeks and days leading up to the death of Cooper, that on the day there were at least 6 women he was engaged in on the messaging service Kik, in discussing sexual relations, and throughout this he discussed wanting to be with as many women as possible, and his relationship with his wife. And so, Your Honor, we believe that that would just be a proffer of the general evidence related to why this is motive and why evidence involving CD is one of many women that he was engaged with, that he wanted to be able to deal with outside of his marriage, and that's just one of the pieces of the puzzle in this.
If you're ready.
Yeah, I don't need to recall the officer for that.
No.
I say I was ready to look at how many cases.
Take your time.
We go ahead and hand out these cases for a losing hearing. Judge, as I'm just going to address the proffer briefly as to even if everything that the state has proffered were true, and I'll absolutely contest much of it. None of that is evidence of motive as the state is suggesting here. Is it evidence that he is perhaps a philanderer or an adulterer, or a philanderer or an adulterer, or to reversed a conviction in part for improper joinder. And this is Harrell, Harrell versus the state. The docket number is SA1045. It's an misdemeanors or both. A, are of the same or similar character, even if not part of a single scheme or plan. Well, I don't think we have to go any further with that. I think it's clear the state's not even suggesting that they're similar character. Or B, based on the same conduct or a series of acts connected together or constituting parts of a single scheme or plan. Well, there are multiple theories of motive according to the detective. Apparently, this is what the state is suggesting, is that somehow requesting a photograph or disseminating harmful materials to a minor, somehow that those acts are part of a plan for murder. Somehow it's all part of some grand scheme. That's what the standard is. Okay? Series of acts connected together or constituting parts of a single plan or scheme, which means they've got to be connected. These specific charges, this requesting photos or disseminating harmful materials, has got to be connected. Got to have a direct nexus to counts 1 through 5. I didn't ask a whole lot on direct of the officer about as to this motion, but I asked about the specific communications with the alleged victim in counts 6, 7, and 8. I know you took notes. But in a nutshell, this is what he agreed to. That the individual in 6, 7, and 8, Mr. Harris told her that he loved Cooper a lot, that they had taken him to the beach and sent photographs of him at the beach. She opined, gave her opinion that he would never do anything to hurt that baby. That Mr. Harris had told her that he loved his wife and would never leave her. She told the detective that Ross always talks about Cooper, wants Cooper to go to Alabama, and how smart Cooper was. He then talked to her again on June the 30th. He said, she told the detective that Ross Harris had counseled her to stay in school because she was contemplating quitting school. She told the detective that she said she had feelings for Ross, but he had told her it would never happen because he was married. She told the detective she sent him photos, but he never pressured her. When questioned specifically about his wife, when he mentioned his wife, she told the detective he wouldn't say anything bad about her, when Detective Stoddard asked, would he say he wanted to end his relationship or looking for a different relationship, what would he say? And the detective agreed with my characterization that what her response was adamant. No, never. He said he would never leave her. You heard Detective ask, when he talked about his son, what would he say? And her response, again, was about him going to Alabama, that the boy was smart, and that he was handsome. State wants to bootstrap every bad act they can come up with to suggest some grand scheme that doesn't exist. But even if it did, it clearly doesn't include counts 6, 7, and 8. There is no nexus in 6, 7, and 8 to counts 1 through 5. It does not exist. Even if this grand scheme that they're suggesting were true, which obviously it's not, but even if it were, it wouldn't include the very specific charges in counts 6, 7, and 8. Back to Harold. I submit to the court that they haven't met that first part of the standard to demonstrate that it's a series of connected acts, again, as to these specific charges constituting part of a single scheme or plan. But according to Harold, let's say they made that leap. Well, there's a second part of the evaluation, and that is if in fact the court were to find that they were joined, the counts were joined because they were part of a single scheme or plan or based on some conduct or a series of acts connected together or constituting part of a single plan or scheme, the trial court, in its discretion, should grant a severance of offenses if it is deemed appropriate to promote a fair determination of the defendant's guilt or innocence of each charge. In the Harold case, Judge, in looking at the number of charges, the complexity of the evidence, and so forth, there's only 3 counts. Only 3 counts in Harold involving 2 types of offenses. The evidence was obviously not complicated at all. But the court reversed, finding that it should have been severed. There was no single plan or scheme. And I mean, quickly, Judge, I would ask you to take a look at some of the language that the court uses in this case. On page 13, it finds that the failure to sever these counts was harmful error. That the crimes that he was charged with, endeavoring to intimidate a court officer, was of an entirely different nature than animal cruelty. The posture of the defense would have been dramatically different had severance been granted. I think that's exactly what we've got here. We've got the elements of counts 1 through 5, which are murder, felony murder, and cruelty. The elements are completely and totally different than the elements that would be required to prove counts 6, 7, and 8. They're not similar. That's the bottom line. But I want the court to take a look at page 14, and I think that this language, and this is Judge Harris Hines writing for the court, I think this language was chosen very carefully. What the court says is the presentment of the joint charges to the jury in this case serves to demonstrate the value of severance of charges, which helps to prevent a defendant from being forced to proceed at an unfair disadvantage due to confusion of law and evidence by the trier of fact and the smear effect of such confusion can produce. Again, in that case, there's 3 counts. That case is uncomplicated at all. It's an intimidating of court officer and cruelty to animals. But I think when the court uses this kind of language, serves to demonstrate, I think all of us practitioners have got to sit and take notice. They're saying, in the same paragraph, they're saying, yes, where you've got a smear effect, that's going to occur by joinder of unrelated charges, the count should be severed. That's certainly the way that I read what the court is directing us to do in Harrell, and I think that's exactly what we've got here. I don't think there's any way that we can suggest that somehow here the evidence is so intertwined that these could not be tried separately. The state suggests that, well, we're going to have the same witnesses. Well, I suggest that's not the case at all. Maybe the detective. That might be one witness that would be the same. But I would suggest this to the court. It's certainly not necessary to present evidence of a child's death if the state wanted to prosecute Mr. Harris for sexual exploitation and dissemination. They can prove count 6, 7, and 8 should they choose to prosecute that without having to rely on evidence as to counts 1, 2, 3, 4, and 5. And it's the same thing as the other way around. It's certainly not necessary to present evidence of dissemination or exploitation in counts 6, 7, and 8 to prosecute counts 1 through 5. In Harrell, they use some language that where counts should have been severed. As here in this case, I'm suggesting, Judge, the posture of the defense is very different. The defendant is forced to proceed with an unfair disadvantage and smear effect. I think that the state, and they filed a brief this morning that I got a brief look at, I think that the state is going to go to great lengths to argue that, hey, all this comes in anyway, because this is our theory, one of our theories, and so all of this kind of stuff would come in under some grand scheme or design of motive. Even if that were absolutely true, and that were going to come in, that does not mean that severance isn't warranted. And the cases in Harrell discuss this very thing. It's very different. It's a very different thing for evidence to come in to prove a charged offense and evidence to come in as supporting another offense. It's not at all the same thing. And I've got several cases that discuss that. I've handed the court a copy of Carter versus the state. In Carter, that's 261 Georgia 344 1991 decision. The Supreme Court of Georgia reversed for improper joinder. In that case, unrelated murders were joined for trial. And the court, interestingly, reversed for improper joinder, even though evidence of one murder would have absolutely come in as a similar transaction against the other count, as to the other count. And the court talks about, because it makes the posture of the defense dramatically different. That case in Carter talks about the fact that it's not harmless error, even where all of the evidence of the first murder would have come in, and the jury in that case actually acquitted of the other murder. So in that case, the court's saying, look, this evidence would have come in anyway. And not only that, he was acquitted of the second murder, but nonetheless, it dramatically changed the posture of how the case went up and the defense. And they reversed. They found that it was absolutely not harmless error. So again, my suggestion is that here the fact that some evidence may come in as alleged motive or somehow come in to show context, I guess, that doesn't authorize joinder. And I think Carter very clearly stands for that. Why? Because the unrelated charges would dramatically modify the posture of the defense. I've given the court a copy of Brown versus the State, 230 Georgia Appeals, 190, 1998 decision. In that case, the Court of Appeals reversed for improper joinder. Unrelated thefts were joined together. And like in Carter, the defendant was actually acquitted of one of the thefts. And they reversed for improper joinder even though the evidence of one theft would have come in as a similar transaction. Again, what did the court look at? They looked at the fact that the posture of the defense is very different when you're talking about evidence coming in as a charged offense, like here in count 6, 7, and 8, and evidence coming in for some other purpose. The error was not harmless because of the smear effect and the unfair disadvantage at trial. And I would just pose to the court, how could any fact finder not be engulfed in a smear effect where they're evaluating the guilt or innocence in a child death case when simultaneously considering guilt or innocence in a completely unrelated allegations of a sexual nature with a minor. There's no way. There's no way you can't have such a smear effect there. How could it be suggested that the defendant would not be placed at an unfair disadvantage where the fact finder in a dissemination trial here's evidence of argument in an unrelated allegation of child murder? Very simply. How is he going to get a fair trial on count 6, 7, and 8 if they're hearing evidence of child death? We've all had these cases. We know how intense emotions are during child death cases, Judge. That's absolute reason why severance is warranted and I believe mandated in this context. I've given the court a copy of Smith versus State, 249 Georgia Appeals 39. That's also a 2001 decision. Court of Appeals reversed for improper joinder. That was a burglary rape trial that was tried with an unrelated child molestation. The state in that case concocted a theory that it was all part of a common scheme to prey on vulnerable peoples because one was a woman who was injured and one was a child. The court found that was absolutely not part of a single crime spree or carried out in some similar manner just because the state said so. The court found evidence of a lustful disposition for children would not show a bent of mind to commit a rape of an adult woman. And I think we've got a similar argument here. How is what's charged in 6, 7, and 8? Requesting photos or disseminating information like that. How does that show some disposition to want to kill your child? Court found reversible error as a result, again, smear effect, unfairly disadvantaged the defendant at trial. These are terms that we hear very occasionally in the criminal practice, and we throw them around sort of cavalierly, smear effect. It's easy to discount that, frankly, Judge, because we hear it so much. These cases, and the Harold case says it's real. We don't discount it. There is such a thing as smear effect. It does change the dynamic of the defense of the trial, and it's got to be considered. And lastly, I've given the court a copy of Haisman, H-A-I-S-M-A-N versus the state, 242 Georgia, 896. That's a 1979 decision. In that case, the court reversed for improper joinder for unrelated involuntary manslaughter or murder. Factually, both killings involved family members, and both killings involved an allegation of poisoning. And the state's suggestion was that there was a common scheme or plan to poison family members. And the court reasoned that it can't be a common scheme to poison family members where one of the counts was involuntary manslaughter, which is an unintentional killing. We've got the same problem here. Count 3. The state wants to suggest some grand plan between these unrelated offenses, part of an intentional plan. But in count 3, Judge, Mr. Harris is not charged with a malicious killing. He's not charged with an action that would be part of this grand scheme. What he's charged with is a killing resulting from negligence, not malice, not intent to kill. That's the problem that the court found in Haseman. That's the exact problem they found in that case. And Haseman says, under such circumstances, the other charges cannot be part of a scheme motivated by a killing not charged as an intent to kill. I think we've got the same thing here. I think it's a serious problem, and I certainly think it more than warrants severance under these circumstances. I think the court understands very clearly what our position is and why. The state did file a brief this morning, Judge. I'm going to ask that you please read these cases, and if you need further written response from me, I certainly don't. I don't mind doing that. I think this is an extremely important issue for the trial of this case.
Argument.
Thank you, Your Honor. I think the key phrase used by the defense that keeps coming up and coming up and coming up again in the cases they're citing is the term unrelated. In all these cases, the defense cites these are offenses that have been improperly joined because they are unrelated. Our argument, Judge, completely in this case is that this is completely related and admissible for several reasons, as I've enumerated in the brief I provided, Your Honor. Just to kind of start, I believe I laid out kind of a factual basis in the brief, so I won't belabor that. I believe you've heard a lot of proffers and evidence from Detective Stoddard regarding why this evidence would be appropriate and why it shows motive and what the motive is in this case. So I'll leave it to Your Honor to read any further into the statement of facts in the brief, but I believe it's clear why we are seeking to admit this evidence. First of all, the motion to sever should be denied for several reasons. First of all, because this is evidence of motive. This isn't these other acts, not just for what CD was a victim of in counts 6, 7, and 8, but this other evidence that we're going to be seeking to admit is all evidence of the defendant's motive to dissolve the family relationship, to get out of it, and to escape it. These are the defendant's words on the morning of him deciding to kill his child, not my words. Escape. We believe that the evidence relative to counts 6, 7, and 8, that relationship with CD, the messaging, the back and forth, is all relevant as first intrinsic evidence. We believe it should be admissible, which I guess is kind of a new term as far as state view of the evidence code, because now we're patterned after the 11th Circuit, and so we need to look at that. Second, we believe that it's evidence just simply as motive for the offense, and the defendant's statement of mind leading up to and on the day of the indictment. Just to kind of respond to one thing the defense said already, he talked about count 3 and criminal negligence and things like that. Basically, that count, they're not mutually exclusive verdicts anymore, and if a jury believed everything the defendant says, in this case he is still guilty of criminal negligence, his messaging with Chelsea Doster, or excuse me, with of that person that day, is part of negligence, if you believe everything the defendant says. While his child's sitting out there in the car, he's messaging all these people, including this minor, about sexual topics and things like that. But regardless of that, it also shows the defendant's motive and his desire to carry on affairs outside of his marriage with numerous women, and the motive it adds to clear this hurdle of having a family in the way of this. Also, just assuming arguendo, these cases had not been joined together, or for some reason, if Your Honor does not find them to be intrinsic evidence or motive evidence outside the purview of Rule 404B, we would ask and we would argue that these would be extrinsic evidence then admissible pursuant to 404B as evidence of motive, as evidence of the circumstances of the crime, and as evidence of absence of mistake or accident. Generally, the standard judges I've laid out in the brief kind of sum it up. If an indictment has been joined solely for the purpose of the offenses being similar, the defendant has an absolute right to sever. So if the only reason they were severed or joined together, like some of these cases the defense is arguing, two murders that have nothing to do with each other, two burglaries that have nothing to do with each other. If they're just joined because they're similar in character, you should sever. However, if the offenses are not joined solely because of the same or similar character, and Judge, we're not even arguing that these offenses in 6, 7, and 8 are in any way similar to killing your child. So thus, it would not be severed by common sense, or not joined solely for the purpose of having similar character charges. If they are not joined solely because of same or similar character, a trial court must decide whether it would promote a just determination of guilt or innocence. And the Supreme Court has gone on to lay out what this means. Griffin versus the state, which is 292 Georgia 321, that's a 2013 case. They held that the relevant factors in making this determination include whether, considering the number and complexity of the offenses charged, the trier of fact can parse the evidence and apply the law with regard to each charge, and whether evidence of one offense would be admissible in the trial of another. Here, there's not going to be anything about the number or complexity of counts in 6 through 8. This isn't some 45-count RICO indictment. Nothing about the number of counts that in any way hinder a jury from analyzing evidence and applying the law to each charge of the indictment. Also, the jury will hear evidence of counts 6 through 8 upon the trial of counts 1 through 5 anyway, thus severance should be denied. And I make that statement because the courts in Georgia have been clear. When you have a case, as Coop versus the state, 327 Georgia Appeals 642, 2014 case, which is citing Simmons, a Supreme Court case, states that, quote, where evidence of one charge would be admissible in the trial of another, a trial court does not abuse its discretion in denying a motion for severance. So, Judge, first of all, your decision here is going to be reviewed on an abuse of discretion. You do not abuse your discretion when you deny severance, when the evidence of one set of offenses is going to be admissible in the other. Trial courts properly deny severance where the evidence of two separate offenses are inextricably intertwined, or where the evidence is admissible as motive of the other evidence. And I've stated before, under 404B, if those did not win the day, then this would be admissible under 404B as motive, absence of mistake, accident, or the circumstances surrounding the charged crime. And I will note, Judge, just for the record, that under 404B, now, additionally, if it was not just for general motive, this evidence would be admissible, we would not have to give notice in seeking to introduce this evidence under 404B as evidence of proving the circumstances surrounding the crime and motive. First of all, talk a little bit about the fact that severance is not required. One, the first reason is that this is intrinsic evidence. In United States v. Ford, which is a 2015 11th Circuit case, which, as Your Honor well knows, we've been instructed by the legislature and the courts now that when we analyze the new rules of evidence, we are to look to and follow the 11th Circuit and how they apply the federal rules of evidence when our rules are patterned after them. United States v. Ford held that Rule 404B is the wrong place to begin the analysis. That first of all, the court should determine whether the conduct is admissible as intrinsic evidence. Intrinsic evidence is generally, quoting United States v. Troya, that's Troya, it's generally admissible if, one, an uncharged offense which arose out of the same transaction or series of transactions as the charged offense, it's admissible. Two, it's necessary to complete the story of the crime. Or three, it's inextricably intertwined with the evidence regarding the charged offenses. And Judge, you have to look at the cases to see what they mean by those things. And looking at State v. Troya, Troya, the 11th Circuit held that evidence that is not part of a crime charge but pertaining to the chain of events explaining conduct, motive, and the setup of the crime is properly admitted if linked in time and circumstances with the charge, or forms an integral and natural part of the account of the crime, or is necessary to complete the story of the crime for the jury. The Troya case was actually a defendant who was charged with the murder of 2 little kids. I believe it was 3 or 4 years old. In addition, in the indictment, the defendant was charged with offenses related to drug trafficking and firearms offenses. In that case, the government introduced evidence of uncharged acts as well, including a shooting incident and a home invasion, along with testimony of cooperating witnesses regarding the drug transactions. The 11th Circuit held these acts to all be intrinsic, and judged in this case the acts are intrinsic. They held in that case that it was outside the purview of Rules 404B. They found that the shooting and home invasion were intrinsic because they were done to protect the drug conspiracy and, quote, went to lengths to which the appellants would go to protect the drug trade. They also found the testimony of the cooperating witnesses to be intrinsic because it was crucial to explain the context, motive, and setup of the charge, and was necessary to complete the story. Judge also is instructed to look at cases from other jurisdictions who have already gone through and looked at murder cases or other cases and applied their versions of our Rule 404B, or excuse 404, and intrinsic evidence and things of that nature. The first case is State v. DeBartolo. It's 2000 Washington App Lexus 1195. It's a 2000 case. The defendant there was tried and convicted for the murder of his wife based partially on evidence admitted regarding multiple acts of infidelity on the part of the defendant. This evidence included testimony from women about his complaints about his marriage being poor. In this case, he did complain to CD about the marriage. He also stated that he did not have sex with his wife. That is something that is throughout the evidence in this case will show that the defendant complained consistently and constantly about his sex life with his wife. Also that he was tired about his wife nagging about his affairs with other women. In this case, CD told the police that the defendant had admitted that he had cheated on his wife to her. The Washington Court of Appeals found that the trial court properly admitted, quote, evidence of marital disharmony and infidelity not only as motive and intent pursuant to 404B, but also held that it was admissible to have a more complete story of the defendant in the weeks before and after the crime. We believe that that is completely analogous here, Judge. Also, in looking at the term inextricably intertwined, which the 11th Circuit has used, I'll turn your honor to the Coop decision. This is where the court properly denied a severance of offenses, where you had basically 3 offenses. You had a robbery that was committed 3 months prior to a burglary that was then committed, and then I believe there was a terroristic threat added on at the end too, made toward law enforcement. So basically you had several offenses in one indictment, 2 of them disconnected by 3 months. The court held that the offenses were properly joined because they were intertwined such that, quote, some of the same evidence would be required at the trials, separate trials on each charge, as evidence of both crimes were found in the same location, same witnesses would have been required to testify. Here, Judge, the evidence relates to both offenses being found in the same location, which were the defendant's phone and his internet records. The same witnesses would be required to testify. Detective Steyer, CD, the computer forensic experts who would testify. All of these witnesses would be the same in one trial as the other. And also the same witnesses would be required to testify as to some of the evidence in this case and interviews of CD. Thus, this case, or this evidence regarding the involvement relationship with CD, including the crimes, would be admissible as intrinsic evidence. The second reason it would be admissible, and thus Your Honor should not sever the counts, is that they would be admissible as motive, the evidence from counts 6, 7, and 8, as to proving counts 1 through 5. Motive has been defined as, quote, the reason that nudges the will and prods the mind to indulge the criminal intent. That's Bradshaw versus the State, which is 296, Georgia 650, 215. Where one evidence of one set of offenses would be admissible as motive for subsequent offenses, a motion to sever is properly denied. That's Griffin, as we talked about earlier. Also, the defendant's motive for committing a criminal act is always relevant, a relevant inquiry on the part of the state. Now, the defense can sit up here and argue that we don't need this and we don't need that. Well, quite frankly, I'll be happy to try my case the way I think I want to try it. And I'll be happy to prove motive if we had it. Even if it looks bad on the defendant, it is still relevant and important evidence to show why somebody would commit an act so horrible. I'm sure one of the main arguments in this case is going to be, you can't imagine, it's just impossible that somebody would go to the depths of killing a little child in a car, their own flesh and blood. Like, nobody would do that. When you have a case like this, even though motive is not required, we sure as heck are allowed to and should prove or show some of the reasons why somebody might do something that horrible. And Georgia law is clear that we are allowed to do that. The Georgia Supreme Court has consistently held that evidence of motive is admissible in murder cases for such seemingly senseless killings. Your Honor, I've cited in a footnote several cases involving murders with unbelievable motives, admissible motives, and motives for murder all the same. Cook versus the state, which Your Honor may be familiar with, it was a Superior Court judge in Fulton County who was murdered by her son. The motive in that case being family problems, including the defendant's drug use and bad grades. Dorsey versus the state, you actually had the murder of a sheriff-elect because the sheriff in office orchestrated it to keep from having his corruption exposed. Your Honor, looking at Riley versus the state, it's an example of authority in this case, in this state, and unfortunately it's not just relegated to this state, where senseless and shocking murders of children have happened for admissible motives that are just as senseless and shocking. Riley versus the state, which is 278, Georgia 677. Defendant there murdered 3 children via fire. In that case, evidence of marital problems in the defendant's romantic relationships was held admissible to show how the defendant, quote, viewed the children as a source of friction. State versus Farguson, 1996 Supreme Court case. The defendant in that case smothered her 6-year-old daughter to death. The court allowed evidence of motive in that case. In that case, the motive was the defendant's desire to rid herself of her child because her current boyfriend did not want to raise another family. Lyles versus the state, a 1959 case. These cases go back years, where a defendant had poisoned his 9-year-old daughter or her 9-year-old daughter to death for no cause except to satisfy her selfish desire for money. And, Your Honor, these seemingly unfathomable motives in trials for the murders of children is not simply novel to Georgia. This year, 2015, State versus Todd, Ohio. Ohio appeals Lexus 2564. Defendant there was convicted of murdering a 7-month-old child, quote, to obtain an amount of personal freedom and to free herself from her responsibilities as a mother. In another Ohio case, State versus Webb, defendant killed his son after setting fire to a home with his family still inside, and evidence of extramarital affairs was admitted to show motive in that case. Also, State versus West in Connecticut. The defendant in that case was convicted of murdering a 7-year-old and severely assaulting a 2-year-old with a knife after having staged a fake home invasion and stabbing the children. Motive evidence was admitted in that case, quote, that was almost as unfathomable as the crimes themselves. The defendant thought that by killing Gerald and Lindsay, their father, Arnold Collier, C-U-Y-L-E-R, with whom the defendant was romantically involved, finally might agree to marry the defendant and move out of state with her. While the admission of motive evidence, while not required, it is of particular importance in cases like this, and our courts have recognized the state's right to present such evidence in support of the state's theory of guilt for over a century now. Going back to Sterling versus the state, which is an 1892 case I cited in a footnote, the prosecutor may advance any theory as to motive which is not absolutely inconsistent with the facts. Wall versus the state, evidence of motive is always relevant and admissible. Your Honor, I know this is kind of different for me. I'm citing a treatise. getting into this and researching this topic, I was trying to learn again about blue books and things like that. I don't think I did it correctly, but I at least learned again what CGS is, what American jurisprudence is, and things like that. And these are instructive about the general admissibility of motive. First of all, quote, at least to a slight degree, it tends to establish the existence of the motive relied on. Further, it's generally understood that in criminal prosecutions, whenever the motive or intent of the accused is important and material, a somewhat wider range of evidence is permitted in showing the motive or intent than is allowed in support of other issues. Otherwise, there would often be no means to reach and disclose the secret design or purpose of the act charged, in which the very gist of the offense may consist. Such intent and motive may be proved by either direct or circumstantial evidence, and evidentiary circumstances which are relevant to or tend to shed light on the motive or intent of the defendant should be admitted. In addition to cases specifically admitting evidence of marital family discord and infidelity as motive in murder of children, our courts have also repeatedly and consistently admitted the same motive evidence in a variety of other cases. And Your Honor, I won't belabor it. There are a number of cases I cited in the footnote which allow this type of evidence. The same can be said for courts throughout the country. State versus Auersweld, Auersweld, another Ohio case. I'm trying to comment on Ohio. It seems like a lot of unfortunate things are happening there. In that case, you had a defendant who was convicted of murder for poisoning his wife with antifreeze. And evidence of marital discord and infidelity was admitted to prove the state's theory that the victim impinged upon his desire to live a bachelor lifestyle and be with other women, which is exactly what we have here. This evidence included, similar to ours, emails more than 3 years before the murder regarding marital discord. Emails to coworkers after his wife's death stating that he'd fallen in love with another woman online. And also, online messaging with an unknown female some 9 months before the murder discussing his desire to share photographs and engage in a relationship with the female. Your Honor, here, the evidence of defendants' consistent, ongoing, and pervasive attempts and successes at times at having sexual and romantic relationships outside of his marriage is no doubt relevant to his motive for homicide, i.e. to escape the bounds of his family to pursue his personal sexual interests. This is highlighted and integral to the crimes charged in counts 6 through 8 involving his relationship with CD. He sought her out almost a year before the murder and continued the personal sexual online relationship up until and on the day of the murder. Now, and the defense argued and asked questions to the detective, well, his family didn't get in his way of doing this. We expect the evidence to show that but for his child and his wife, he would have been much more successful and gone out on much more occasions to engage in these acts with other women. Your Honor, he even refers to himself in some of these messages, the defendant, as a, quote, sex addict, and that he is addicted to sex, and it's a habit. Your Honor, this evidence of the need to further a habit is also evidence of motive. In the Graff case, which I cited earlier is in the brief, that's GRAF, the defendant was convicted of burning down her own house. The motive alleged in that case was that she was a drug addict and needed money to further her habit. There was not only evidence admitted that the defendant was in possession of cocaine and marijuana at the time of the arrest for arson, but also the defendant was charged in that indictment with the possession of the drugs that were found on her. And they were joined in the trial of the arson. So they were tried together. It wasn't like they were indicted together. 2 separate indictments actually joined for trial. And that was upheld. The court held that joinder was proper, as evidence of the drug possession crime helped to prove the motive for the arson, i.e. to further her habit. Here, the evidence of the offenses in counts 6 through 8 is admitted to prove the defendant's motive for furthering his habit and his own self-described, quote, sex addiction. Further, Judge, and finally, as far as reasons why this evidence would be admitted in trial, even if it had been severed or would be severed, assuming arguendo that counts 6 through 8 are not intrinsic or motive evidence, they would be admissible under the Georgia Rules of Evidence 404B as extrinsic evidence. As they are proof of the circumstances immediately surrounding the charged crime, motive, intent, and absence of mistake and accident. Regarding the proof of circumstances immediately surrounding the charged crime, I believe it's pretty obvious, Judge, from what we presented here today. I won't belabor that. Specifically, the defendant had engaged in messaging photographs of his penis, photographs of CD's breasts were sent to him. All of this going on while Cooper was in the car on the day of his death, the date that he was charged with murder. Also, this would be admitted as motive evidence pursuant to 404B. In United States v. Poole, which is another 11th Circuit case, 451 Federal Appendix 298, 2011, the defendant was charged with conspiracy to commit mail and wire fraud in connection with the murder of his adopted parents. There, the court admitted evidence of the defendant's infidelity and extravagant lifestyle for the purpose of showing motive pursuant to Federal Rule 404B. Additionally, other states have held admissible under their versions of Rule 404B evidence similar to this. In Hill v. Estate, which is a 2001 case out of Mississippi, the defendant murdered a child and evidence of motive was admitted pursuant to their 404B. The evidence there admitted was that the defendant and her husband were arrested and that the defendant bonded out and killed the child. The motive being to collect life insurance money just so the defendant could afford to bond the husband out of jail. So, whereas the defense may get up here and argue, oh, these are crazy motives and this is so attenuated, if these cases and if the news and life have shown us anything, there is no limit to the horrors that people will inflict on children for their own selfish needs. Regardless of the introduction of evidence regarding the introduction related to counts 6 through 8 for the purposes of intent and absence of mistake, as the cases, the Supreme Court of Georgia has recently ruled in Bradshaw v. Estate, which is 296 Georgia. This would be at 656 and 657 of that opinion. The defendant puts the question of intent at issue when he enters a plea of not guilty, and the state may then show intent. Your Honor, malice is actually an element of counts 1 through 1, 2, and 4. 1 being malice murder, count 2 being felony murder, based on a cruelty to children that requires malice. Lackey v. Estates held that malice is a state of mind and frequently must be proven indirectly. Further, the Lackey court went on to hold that whether a child has been neglected and abused with malice so as to constitute murder, or has merely been harmed as a result of the inability, careless, or accident, may often require considerable indirect proof to determine a parent's state of mind. The evidence related to the offenses against CD are significant evidence of his intent and state of mind and would be necessary to rebut claims of mistaken accident. Finally, Judge, in looking at the defense's motion, they didn't argue this much in their argument, but it is in the motion. They argued that the only reason for including counts 6 through 8 in this indictment is to inflict and interject bad character into the trial of the murder charges. In just addressing that, Judge, I think we've heard... Okay.
Did we lose Mr. Kilgore?
We did.
Because...
He had to step out in some emergency.
All right. Are you all going to cover for him and be able to respond, or?
Would you be able to take a break as soon as Mr. Moore is done?
Well, I think that if Mr. Kilgore is going to respond to what Mr. Warren says, it'd be better if he hears him. How long do you think it'll be?
I don't know, Judge.
Oh, well. We'll take a break. Y'all go find out when he's ready to go back.
Robert.